And so the Mayflower is like a...
Good evening. Welcome to the Appellate Division First Department. I'm Presiding Justice Dianne Renwick, and this is our second event for Black History Month. We are so pleased and grateful to Judge Rosenblatt for spending the evening with us to discuss his book, The Eight, The Lemon Slave Case and the Fight for Freedom. I'm going to be asking Justice Rosenblatt some questions about his book, and he is well-versed in answering them. He will be using slides. He has spent quite a long time thinking about this book and developing further ideas for it, film, blogs, traveling boards that have been of museum quality to tell the story, storyboards. So without further, we'll get started. Just let me first begin by telling you a little bit about Judge Rosenblatt, while I'm sure everyone knows him. But you know, you're known as the Renaissance man. I guess you know that, right? By many because of his professional, intellectual, and athletic pursuits. I know you're very modest, but so accomplished. He is among the most well-known and highly regarded members of the New York State judiciary. And by the end of this evening, you'll know why. His lifelong love of learning and his innate curiosity have led him to explore many different topics and write on several interesting essays, articles, and books, all of which inure to our benefit on all of those topics, I understand, skiing as well. So Judge Rosenblatt grew up in Washington Heights. He's a graduate of the University of Pennsylvania and Harvard Law School. He began his legal career in private practice and then worked in the Dutchess County District Attorney's Office, and before long was elected District Attorney of Dutchess County. A few years later, he embarked on what would be a very successful judicial career. He served as Dutchess County Judge and then a Justice of the New York State Supreme Court, and then a rare turn for, I think, the majority of people who go through civil court and Supreme Court. He served as the Chief Administrative Judge of the state, and then as an Associate Justice of the New York Court of Appeals. While at the Court of Appeals, in addition to authoring scholarly decisions and opinions, he was also instrumental in creating the Historical Society of the New York Courts with Judge Judith Kaye. And his retirement has not slowed him down at all. He still loves and actually teaches skiing. He loves Sherlock Holmes and has written about both, right? And most of all, I would say he loves the law and he loves history. He is a lifelong student of history. And this evening, he combines both in the story of The Eight. You've spent, as I said, lots of time. Anybody who reads the book, it's a real scholarly work, so well researched. And so I'm excited to have you speak with us this evening about this. And I think we should start at the beginning because the Lemon Slave case takes place in about 1850 is when that sort of starts. It's hard to believe that this case is part of New York State history, and yet I don't know about any one of you, but I wasn't aware of it until Judge Rosenblatt brought it to my attention, brought it to all of our attention. And that's sort of remarkable because it really, the Court of Appeals stood up against the Supreme Court despite the Dred Scott case. And when I say that, you know, I'm surprised that the walls here don't shake and reverberate and, you know, because right above my head in this dome is the name Taney, as in Roger Taney, the author of the Dred Scott decision. Judge Rosenblatt and I were talking about just how awful it is that in 1896, when they built this court, they thought it important to put his name in this dome. With so many statements about the law and about justice and about equality and about wisdom. And then we find Roger Taney. So it's quite interesting. But, before I say too much more, we want to hear from you. So why don't you tell us about, where it began in this state? Because before slavery was abolished in this state, New York State, it thrived.
Yeah,
so,
It did thrive, and we have the, I'm going to advance this so that you get, if you just look at that a little bit, you get a pretty good idea of the chronology, the so-called bookends, and you'll come to appreciate that slavery began with the Dutch when we were here as, I say we, I mean to distinguish the European landing in what is now New York. The Native Americans had been here for centuries before then, but we speak of Dutch New York because that's closest to our culture. And with the Dutch, slavery existed, but it was not institutionalized. It became institutionalized with the British when the British put the Dutch out somewhat by force in 1664 and wrote a code where slavery was actually recognized as a lawful practice from 1664. 100 years then, we're a British colony until the Declaration of Independence in 1776, when we say all men are created equal, while at the same time, a sizable proportion of our country is treated not only unequally, but treated as chattel. And that's one of the early hypocrisies that we look back on now with regret, that we could have used those kind of words, recognizing that so many souls were not seen as equal. So there's a remarkable sort of arithmetic number in all this, which is that if you were to calculate the amount of time that we, and I'm saying largely as Europeans, people from European, Asia, maybe eventually from Africa, got here to these shores, it's been about 400 years since, say, the 1620s. So we've been here for about 400 years after Native Americans. We've had slavery in New York more than not. So the majority of those 400 years, we had slavery. It began to be abolished in 1799 when John Jay was governor, and it took about 28 years to abolish it gradually. So the last slave was freed in 1827. Then 25 years go by, and we have the Lemon slave case. So just wanted you to appreciate that time span, so you get the chronology in your mind. Some people grasp things better when they appreciate the, sort of the chronological bookends. I became interested in the case when, like...
You took my question, but it's okay. You took my question. You're reading my mind.
Oh, go ahead.
No, that is the question. How did you become interested in this? Because it was a long time ago that I remember speaking with you about this, before the book was written. And a lot has happened in that time. So why don't you talk about that?
Well, I was in the building, just like you're in the building here, and you look around and you see things, and there's history all over the place. And we were aware that the court decided, this is when I was in Albany on the Court of Appeals, the court decided important cases. We had a vague idea of it. We knew we decided Lochner, we knew this and that. And we knew that there was a Lemon case out there where we sort of somehow got out from under the United States Supreme Court ruling in Dred Scott. How in the world that happened, that's a story in and of itself. When we get to that point, I can, as lawyers, tell you about the sophisticated means and the deftness in which the judges were able to get out from under Dred Scott. It was very, very deft indeed. So along comes COVID, And I started writing the book a few years back, but with the COVID, we're locked in the house, and I'm cabined in there in front of the computer for maybe 12 hours a day, and got better and better at it. You have no choice but to get better at it. And after a while at the computer, I was able to identify search engines that I never thought I would ever find. And reached the point where I could find marriage records in Michigan and find the minutes of the Chicago City Council in 1854 and so forth. So it's all out there on the internet, and I was sort of forced into these search engines, and that provided a framework for what ultimately turned out to be the book. So that's how it started.
And now before you actually, even before 2020 and COVID, you had developed these museum quality storyboards that were circulating, right, around the state, which cataloged the history of the lemon slave case.
Yes,
And
there are records.
yeah, and then after that, I think maybe a blog with Mustafa Khan, I think maybe?
Yeah, Mustafa
so-
Khan, yes. And we began by having a display in the courthouses all over the state about the lemon case with posters. And it went to about 80 courthouses and roused a little bit of interest. And at that point, my partner in this said, you know, you really ought to do a book on this. And we're giving smatterings here and there. And we came to learn that there are records. For those of you who know your way around the books, you could find the initial ruling in the Lemon case, and I'm going to tell you about that ruling in a moment. It's in 5 Sanford's reports. Not easy. It won't appear on Westlaw, but it won't appear on Lexis, but you find it on Westlaw. It's in 5 Sanford. The Aptiv version of the case is in Barbour, B-A-R-B-O-U-R. And some of you may remember those oldies but goodies when you cite a Barbour site. Wow, you're right, Richard, you're really citing a Barbour case. That's pretty good. So, and then when it reached New York, it was 20 NY, not NY second, not NY third, but 20 NY. So with that, I think I'll go into a little bit about the background of enslavement and leading up to the Lemon case. Okay?
Can I just stop you a moment? Your microphone has fallen down at your lap there. You see so that part is okay. Click.
Thanks, Sam.
So it might not.
Leave it here.
Um,
How many of you have seen Naked Gun 5 with Leslie Nielsen? Oh, okay. Do you remember? No, you're laughing. Oh, he was mic'd, and he didn't realize he was mic'd, and he goes into the men's room, and it brings the house down. One of Hollywood's funniest scenes. So what do you think?
Great. Can that go into that pocket?
This will go maybe into this pocket?
Okay. Just this.
How's that? Is that
If
broadcasting?
that works, sure.
Broadcasting?
Hopefully it won't pull off.
And Boris told me how to operate this. He said, big button forward. There we go. So this demonstrates that as late as 1790, we in New York were just ending the practice of slavery, and we're still talking about catching runaway slaves. Now, I wanted to show this slide because it shows what I think is such an extraordinary inconsistency in the attitudes, in the racial attitudes that existed at that time. Mingling of the two races was unacceptable and indeed illegal until, as some of you know, Loving Against Virginia, that's in the late 60s. So this is a long time before Loving Against Virginia, and marriages were illegal, of course. Rape was not illegal. Rape was the order of the day, and that's why we have so many mixed race people, because the slave owners would themselves often go into the slave quarters and have their way with the slave women or invite their friends in and creating races of mixed race people. What struck me as so extraordinary about this is that given these laws that created a legal barrier, what could be more intimate than the routine practice in the South? What's more intimate than black women breastfeeding white babies? When I saw that, I thought, oh my goodness, isn't that extraordinary? And this is a common picture. And you see the picture there, the other picture, not breastfeeding, but the same kind of loving relationship. So that immediately struck me as one of the oddities about racial differences and laws and barriers.
It is. I understand why it seems so odd and just doesn't seem to make sense. But in that way, black people were thought of as animals. And we take milk from cows. So this is a very convenient kind of animal who can hold and nurture and, So in that sense, as awful as it sounds, as barbaric as it sounds, it was awful and barbaric, but that's probably why Taney and the rest were able to,
Interesting.
Ignore, that
Interesting.
absurdity.
Indeed.
But you've talked about, there was one other thing I wanted to mention, and that was you had said, I think that slavery took a while before it ended, right? About 27 years or so. I think that sometime around that time, slavery ended in the United States. I guess it was slavery, the importation of slaves ended.
Right, exactly.
But slavery didn't end for many, many years. Tell us about
What
that.
a good point that is. Justice Renwick explained something that we can appreciate as lawyers. In the United States Constitution, drafted in 1787, it says that the importation of slaves must stop. That was something the Northerners bargained for. The Southerners got their bargain in the United States Constitution. If you read it today, you'll find the Fugitive Slave Clause obligating judges to give slaves that are runaway, give them back to their owners. That's in the United States Constitution today. You'll find it right there. You'll also find the 3/5 clause in the United States Constitution today. Some of you are recognizing that, you're shaking your heads. But also in the United States Constitution, there was a decree that the importation of slavery would end in around 1804. What does that mean? It doesn't mean that slavery ends. It means that the importation of slavery ends, but slavery flourishes. Let's say there was 500,000 slaves before 1804. The South could get by with that because, you know why? The children took on the status of the mother. So the more women were impregnated, the more slaves there were, so that by the time of the Civil War, there was 4 times that many slaves in the South. There were about maybe 500,000 slaves in Virginia alone. This is notwithstanding the illegality of importing slaves, because they would simply reproduce. And the slave owners and slave power would see to it that there would be what they called increase. That's the word they used. It was kind of a euphemism, but by increase, people know what that meant. More slaves, more pregnant black women, more slaves. They did not take on the status of the father, they took on the status of the mother. That was written down in Southern codes.
And were slaves ever used, the number of slaves ever used to the advantage of the South?
Yeah, oh my, that really tells the whole story. It goes for a little bit of historical treatment, nothing that you probably don't know about. We've learned about this maybe as freshmen or maybe high school seniors or somewhere in there, but it's good to remember this. When we all met in Philadelphia, we, the corporate we, and wrote the Constitution, the question is, how do you have representation under the first branch being the Congress? Well, we decided to have a Senate 2 senators from every state, big or small. So the big states have 2 senators, and the very small states have 2 senators, and we live with that today. What about the House of Representatives? That's based on the population of the state. So the South said, well, we in Virginia, South Carolina, Georgia, North Carolina, well, we're big states. And the South says, well, are you counting your slaves? Say, yeah, of course we count the slaves. And the Northern said, how can you count the slaves? You don't regard them as people. He said, well, for this purpose, we want to regard them as people.
Another convenience.
Right,
Another mere convenience.
Yeah, indeed. So they compromised at 3/5. And for every 5 slaves, were counted as 3 people for purposes of representation in the House. This compromise gave the South enormous slave power so that they were able to write the Fugitive Slave Law of 1799, which was a monstrous piece of lacking due process, saying, find the runaways and throw them back south anyway, no due process. And worse yet, the Fugitive Slave Act of 1850, find the slaves, give them back to the owner, no due process. Not only that, but at a hearing as to whether somebody is a runaway, the enslaved is not even allowed to testify. Talk about due process. So that was slave power that the South gained, enabled to write congressional statutes that were designed to perpetuate slavery.
Now this slide that you've brought up here, bias to, I think, tells another piece of underscores slaves as property completely, and that their families were torn apart, such to the extent that people were begging to be purchased along with the husband, the father of the child, so that they could at least stay together. And that, of course, we know was not the case.
Think of the poignancy of a drawing like that, By Me Too. It was an imperative element of the slave practice that families be broken up so that the loyalties would run to the owner and not to each other. Families had to be broken up, so the mothers were sold, the fathers were sold, the children were sold, kept apart in this monstrous arrangement. And it's epitomized in the drawing where the mother's crying, they just sold the baby, and the mother's saying, buy me too. And that was common. This is one drawing that really epitomized the practice as a whole.
So I've kept the suspense long enough. Why don't you tell us about the Lemon slave case? I mean, it was an interesting case, but you really brought the people alive. I mean, I think that's why you have this book, and it draws you to it, because there are these 8 people who you give names to, you give intelligence to. They had it. You brought it to the surface. I mean, by showing what they were capable of, their strength, their wherewithal to survive these conditions and make determinations about themselves and the children who they were responsible for. So why don't you tell us about that part
itself.
and why, the case itself.
Okay. Just quickly,
Although a few other
this
things.
is how the South legitimized in their eyes slavery. Oh, that slaves are just so happy they're sitting there playing the banjo, and there's a lot of pictures like that.
And I think that one was used for a tobacco ad.
This illustrates something else that precedes the Lemon case, but it's very important. It'd be unfortunate if we came away believing that enslavement was undone by white supremacists alone. There was a lot of activity among the African American former slaves in the churches, in the streets, in political ways, so that the Freedmen's Journal was one of the first voices of the blacks, where they too were real players in the effort toward abolition. I took that because I'm from Dutchess County. I really enjoyed that. We actually found the location of this house where they held an anti-slavery meeting. It's in my town. I live near Poughkeepsie in Pleasant Valley. And when we found the house that this was owned by this chap, by the chap mentioned in that notice. So here we are. We know what the Lemons look like. The Lemons were an ordinary couple. They weren't rich slave owners. They weren't, as we know, good people, bad people. They were sort of typical Virginia people who were struggling, but like other people in Virginia, they had enough money that they could have a few people enslaved. And the spectrum went from the very rich slave owners, like the Jeffersons, with hundreds or thousands of slaves on the plantation. The average family in Virginia, according to my research, had 8 slaves. So there were some that poorer that didn't have maybe 1 or 2, and there were others that have thousands, but the average was 8. So by coincidence, the Lemons happen to have 8. So in that sense, they're an average family. They're trying to make a living on their farm, and they cannot do so because the 8 enslaved do not lend themselves to farming. 2 moms, 2 young lads, and a bunch of tots. And you can't run a farm without, heavy labor. So they said, okay, we're going to leave Virginia. And where do you think they would go? When you leave Virginia in 1852, Texas beckoned. And Texas is saying, hey, come on to Texas. We just joined the Union. A lot of land. Slavery is here. Land is abundant. You can make a new life for yourself in Texas. So they start heading for Texas. Getting from Virginia to Texas in 1852 was not easy. It's not like today you get into the car, turn on the conditioner, and you drive in a few hours. It took them 16 days to get from Western Virginia to Richmond, Virginia. This is where they lived. And this shows you Texas inviting people. And there is, I was able to make contact with the Virginia government, the highway department. They're very nice people. And when you talk to them, I mean, they're not saying, oh, slavery, we don't want to talk about that. These are really open. They understand their history. They welcome questions like this, and they're quite open. And they're looking this right in the eye. So I say, I'm writing a book about people who went with their enslaved across Virginia. Do you have any images showing what it would have been like in 1852? And they say, yeah, we have an image. We can get that to you. So they give us it's called the 3-notched road to get from Western Virginia across the state to Richmond. So it goes like this. They're going along with the carriages, maybe 3 or maybe 4 wagons, because there's 17 people. There were 8 slaves and 9 lemons. 9 lemons being the parents and 7 kids. So there's 9 lemons, 8 slaves, a party of 17, maybe 3 or 4 wagons. We don't know. We have no record of that. And the wagons are going through the slush like that, and they're going along and saying, like, where do we go next? And they see the next tree that's marked with 3 notches. So you say, oh, that's the way. Then they go up another few feet. Oh, yeah, that has 3 notches. And they follow the 3-notch trail to Richmond.
Not quite a highway sign. Not quite a highway sign.
Not a highway.
And we complain.
Yeah. So today, you're around Virginia, you can buy 3-notch beer. You see the 3-notch this and that, but it all goes back to the 3-notch highway. Now, right about this time, the Lemons are on their way to Virginia, to Richmond. They want to get to Texas. So here's what happens. They finally get to Richmond after 16 days. And the way to get to Texas from Richmond, anybody know? Can you guess? It's by water. Go down the Atlantic coast, from Richmond down the Atlantic coast to New Orleans, and then inward to Texas. That would have been the route. They get to Richmond, and the people there say, we got bad news and good news. The bad news is the last steamer just left for New Orleans, and the next steamer is not for 2 weeks.
You missed the boat. A day late and $1 short. You know, the early bird catches the worm, and
They missed the boat.
it's the worm, they missed it.
So they say, what do we do? They've got 17 of them. They don't have money for hotels or whatever, and they'd have to segregate themselves anyway. So he said, all right, let's take our chances. What do we do? They say, well, if you could get to Norfolk, from Norfolk, there's a steamer to New York. We're going in the wrong direction here. But if you can get to New York, there's a steamer every day to New Orleans. They say, let's do that. So they get to Norfolk with some difficulty, and in Norfolk, they get the steamer to New York. And then something extraordinary happens on the steamer to New York, which makes this kind of an adventure story. They're on the steamer, and the Lemon family, of course, is in probably third class. We don't know whether they were in second class. I don't think they were wealthy enough to be in first or second. They were probably in third class, which is pretty comfortable. And the 8 enslaved are, of course, in steerage. And they're in the steerage in the bottom deck, and a young assistant chef named Nathan Lobham, a free, former slave, but a free assistant chef, approaches the 8, and he says to them, do you folks want to be free? Just imagine a question like that put to people who can't even process the notion of being free because they were subordinated and dominated their entire life, just the idea of freedom. And the 2 young lads say, oh, no, we don't want that. Like, they're thinking, how are we going to, we'll freeze to death, how are we going to even survive? But the 2 moms, Emmeline, 23, and Nancy, 17 or so, we're not sure of the ages because they didn't keep very good records, as you might imagine. But Emmeline emerges as, to me, one of the great courageous heroes ever. And she says, and Nancy says, yeah, let's take our chances on freedom. They know what it's like to be an enslaved woman in the South because they know they were up for grabs for anybody who came around, and they knew that they could have their partner taken away and sold and have their children sold, so they say, okay, we'll take our chances. So Nathan Lobham says, okay, here's what you have to do. Don't say a word, but when we get to New York, leave it to me, and here's what we're going to do. And Nathan Lobham sends out 3 messages. One he sends out to a conductor of the Underground Railroad who was working around the clock, around the docks. So you know the Underground Railroad. This was it was an entity that was not a railroad, of course, but it was a way of getting people from one house to another, largely Quakers, all the way to Canada. And he sends a note to one person who was active in the docks, a second note to a restaurant inhabited by black people, just to let them know that there are slaves in New York Harbor, and the third, by some miracle, I don't know how Nathan Lobham do it, but he sent it to one of the feistiest, best lawyers that I have ever encountered, a guy named Erastus Culver, and I love this guy. I don't know how Nathan Lobham knew to look for Erastus Culver, but somehow he found him, and this guy was a fighter, smart as can be, nerves of steel, and just a wonderful person. So here we are. We're now in New York Harbor. Erastus Culver has a note from Nathan Lobham saying there are 8 enslaved people in New York Harbor on that vessel. Somehow or other, they contrive to get them on dry land by a ruse, by telling them that they have to stay over to get them on dry land. Maybe, this is all guesswork on my part, maybe Erastus Culver said to the people, the Underground Railroad, look, I have to serve a writ of habeas corpus, right? Of course, that's the vehicle. I don't know whether a writ of habeas corpus works on the water. Do I know? I still don't know the answer to that question. We don't serve writs of habeas corpus on the water. So Nathan Lobham, so Erastus Culver may well have said, look, get these people on dry land. So they're on dry land. They go on a Saturday morning in November 1852, they go down to what is the City Hall, to what is then called the Superior Court of New York. It's now a little bit like halfway between the Civil Court and Supreme Court. They had jurisdiction to issue writs of habeas corpus. They go into the chambers of Elijah Payne, and he's sitting there on a Saturday morning. And I try to paint the scene in the book of him. He just lost his wife. He's a single dad. He's coming to work Saturday morning. He's probably reading the paper. I'm making this up. He's probably reading the paper that Franklin Pierce was just elected president of the United States 5 days ago. So I say, we don't know what he was doing, but there's a very good chance that he's reading the paper about the election that took place 5 days ago. I'm speculating.
I want to know how he knew it was a Saturday morning.
Saturday morning.
You sure it was a Saturday morning?
Yeah, yeah. So right about this time, there were stirrings in New York with abolition, and in Syracuse, when the Federals tried to grab a runaway slave, alleged runaway slave, the Federals put the runaway slave in jail, and the population overpowered the Federals and busted them out of jail. That's the Jerry Rescue. They still have that on a main street in Syracuse, New York. So this was sort of in the air in the early 1850s. There's Erastus Culver. I went online trying to find Erastus Culver. You cannot find him online. But I was able, through various engines, search engines, to find Erastus Culver's great-great-grandson by tracing his lineage through marriage records and birth records and obituary. And I called the guy, he lives in Pennsylvania, he works at a community college, he's an assistant professor, and I say, are you the great-great-great-grandson of Erastus Culver? Sorry, I'm not trying to sell you an insurance policy. And next thing you know, he says, yeah. I said, can you tell me what he looks like? Does anybody know? And he says, I have a picture of him on my mantle. So there he is. He's a good-looking dude, is he not? Yeah. So he's one of my favorite people.
So I still can't understand how Nathan Latham got the 3 notes to 3 different people by the time the ship docked and, you know, he got off. And do we know how long the Lemon slaves were on that ship before they were
One day
started away?
The lawyers knew, Erastus Culver and Louis Napoleon, the conductor on the Underground Railroad, knew that the ship was going to leave to New Orleans the next day. So they had to act very fast, and they go running in. He writes the writ of habeas corpus. Louis Napoleon signs it with an X. Louis Napoleon is the so-called the relator, you know, the complainant. And
Do we know anything about the background of Louis Napoleon?
his background?
Yeah.
Again, we really don't know, but from what I was able to piece together, he's the son of a slave who was maybe born a slave, maybe not, but by 1850, he's not a slave, but he's a passionate activist around the docks, and his records are now at the Butler Library at Columbia, and he arranged for passage on the Underground Railroad of hundreds of people. They started keeping records of the names of these people, and they're all in Butler Library. It's available online. We know that he died shortly after the Civil War, but we don't know much about him because, again, when it came to black folks, they didn't keep very good records unless they were, you know, of extraordinary legacy or backgrounds. Most of them were enslaved, or a lot of them were enslaved, and the slave owners would just say, for the census, oh yeah, I have 8 slaves, ages 3 to 25, and you have to piece it together with their birthdays. The Reverend Pennington was active in the slave case, so when they got to the courthouse with Elijah Payne, Reverend Pennington was on hand, and he was advising and counseling the 8 about what to do depending on how the judge was going to rule.
Keeping them calm, in other words.
Pennington.
I said keeping them calm, in other
Yeah.
words, as you might expect a reverend to do at that point, while
Yeah.
Louis Napoleon,
Yeah.
helped with the habeas, I imagine.
And if he was probably counseling him, saying, look, we don't know what the judge is going to do. This is the first case of its type in the United States. No one was ever asked to free 8 enslaved people merely because they set foot in a free state. That was their argument, that when the 8 reached New York, a free state, they're free. Dred Scott says the opposite. So Dred Scott was out there, but hadn't been decided in 1852.
Right.
So Elijah Payne, the judge, who had a clean slate, he didn't have Dred Scott. The appellate division had Dred Scott, which they...
But that was some years later.
That was 1857, about 8 months later, yeah. So here's Pennington, he's probably advising him, he said, look, if the judge rules against you, here's what I think we can do. Maybe we can appeal, maybe we can do this, maybe we can hide, maybe we can get you on the Underground Railroad. If the judge rules for you, then here's what we might do. We might try to get you to Canada. So he was advising them, and he was quite a figure in his day. There's the judge.
So tell us about Elijah Payne's family and what Elijah does here.
Elijah Payne is nowhere to be found on the internet either. If you look up Judge Elijah Payne, you will find a Judge Elijah Payne, but it's his father. His father was a federal judge in Vermont. So this Elijah was kind of born to the manor. They sent young Elijah off to Harvard at age 15. He was very well educated. Harvard Law School did not exist, so he went to the only existing law school in America, which is in Connecticut at the time, and a lot of people went to this little law school in Connecticut at the time. And he came to practice here, and after a time, he was elected as a Whig, W-H-I-G, to the Superior Court of New York. No sign of him on the internet, no way to find out anything about him, but the Payne family is quite prominent. They're kind of way up there, with the Adamses and the Jays. So I went to the Payne family history and found the family historian and said, Elijah Payne, 1796 to 1853, do you know of him? She says, yes, we know about Elijah Payne. I said, do you know what he looks like? She says, yes, we can get you a portrait. And eventually we were able to get a portrait of him. I learned a little bit more about him, which is sort of a sideline. Then I'll get to that a little bit later. I don't want to go too far off track.
But he's very courageous, obviously. He's a judge. He's sitting there. Maybe because of the family he's born into, he doesn't know anything to anyone, and he signs the writ.
Signs the writ.
And this very unusual first impression case.
Amazing. Signs the writ. And that means, as you all know, that means get everybody in front of me, and then we're going to have a hearing. So they bring everybody in, and now big-time lawyers come in for the Lemons. 2 of the biggest lawyers in New York come in for the Lemons and for the enslaved. 2 very prominent lawyers, Erastus Culver and John Jay II, grandson of John Jay, the founder, and they fight it out. And this is fascinating, and as lawyers and judges, we will appreciate this because we have the record on appeal in which the oral argument, your oral arguments are recorded here, every word, right?
Yes.
Every word.
Yes, and they also see us now. So yes, every movement and every word.
So 200 years from now, if someone wants to hear an oral argument of a case, that would be a matter of record.
Yes.
So we have the oral argument of the case before Judge Payne. The lawyers for the Lemons are saying, as you might expect, being good lawyers, representing their side, the wrong side, but nonetheless, clients say, Judge Payne, you have no right to free these people. We have title. We have ownership. We have full faith and credit. We have title in Virginia. We have a deed that we own them. You have no right to take them away from us any more than you have a right to take away Jonathan Lemon's overcoat or his hat or Mrs. Lemon's shoes. You can't take them away. full faith and credit, and if not full faith and credit, comity, and if not comity, the freedom under the Commerce Clause, the freedom to move about freely. So we've got all kinds of constitutional arguments, Commerce Clause, comity, and full faith and credit. And these are very, very good arguments. And furthermore, the Fugitive Slave Act of 1850 says that that any fugitive slave must be returned to their owners, and you have no choice in the matter, Judge. You must return them. At which point, in the record, Judge Payne says, were they escaping? Were they escaping? And they said, no, no, they were in the company of their owners. He says, the Fugitive Slave Act does not apply because they are not fugitives. Oh my God. Wow. This is some guy, right? You know? Okay, there you are. How about that?
Pretty good.
How about that? Yeah.
It
So
may have
this
led
is
to
a
the
lot- this is
final
why you gotta love
conclusion.
the guy.
You had to have somebody who could think it through. So I have just a question for you. You mentioned that that there was a document produced that demonstrated that the Lemons had title to the slaves.
Right.
Now, was that typical to travel with such documents? Do you think that they were thinking, you know, that did they draft this on their route when they realized they're going to have to go through New York? Was this something you think they thought of? Do you know?
I'm so glad you raised that because it opens up another fascinating avenue. The Lemons were told that it's going to be okay when they get to New York, that New York is not in a hurry to grab enslaved people. There was some truth in that, as you will see, but they did. If they encountered a different judge, it might have been a different story. As we know, not all judges think the same. So we learned, fascinating, that before getting on the vessel to Norfolk, Jonathan Lemon goes to a justice of the peace in Richmond, and he says, I want to have as a matter of record that I own the following slaves. And he names all 8 of them and how old they are. To me, this is a treasure because I had no way of knowing the ages of these people until we found that document. Because in the census records, all they said was 8 slaves ages, 3 to 24. So Jonathan Lemon gave us these records and he wrote them down before a justice of the peace in Richmond. That document exists, and it was held by the family of the Lemon people, and one of the surviving Lemons today, who is a very, very good person, a wonderful person, she donated that to the anti-slavery people. So that's where we've come in a couple of hundred years. But that's how, to answer your question, that's how we came to learn their names.
So they were concerned. They had concerns about going to New York, a state where for a few decades now, at that point, slavery had been abolished.
Right.
And so they knew that they might have a little trouble.
Might have been a little bit risky, maybe. Yeah. They thought they could get by with it because no one had ever ruled that way before. This was the first ruling of its kind in the United States. Maine and Ohio codified the Lemon ruling, but no judge ever had ruled that way before. After the Lemon case came down, and after it was affirmed by the appellate division, Maine codified a similar ruling, and Ohio codified a similar ruling, but that's about all.
So Judge Elijah Payne says, after the hearing, sorry, so sad, they're not fugitives. They were here with you. And case closed? All done?
Liberated. They're liberated, they're discharged. And now comes kind of a little bit of a dismaying part. He liberates them. They're penniless, of course. And the job is for Reverend Pennington and Louis Napoleon to somehow get them out of town. It was very unsafe to be in New York at the time because federal slave catchers were everywhere, and the federal slave catchers could take them right off the street, bring him before some half-baked federal commissioner and send him back south without any due process. Also,
That's remarkable. What one hand giveth, the other one could take away, just like that. It's almost, it's just remarkable. It had no real power in the streets.
imagine that. And the federals were doing this. The federal commissioners were paid to send these are not real judges. They were commissioners. They're sort of half-baked judges. They were paid to preside over hearings to see whether someone was indeed a runaway. Here's how they were paid. If they find he's a runaway, they get $10. If they find he's not a runaway, they get $5.
Wow.
Think of that. Just imagine the due process.
I think that's where they coined the phrase win-win.
Win-win. It's a win-win situation, yeah. And the slaves were not allowed to testify before these federal commissioners. So they knew it was a very unsafe place to be in New York. And furthermore, they didn't even know how the appellate division was going to rule, or the Court of Appeals, or the U.S. Supreme Court they could predict, but they couldn't predict our courts. And they just said, Reverend Pennington and the lawyers and Louis Napoleon said, you guys better get out of here. So they get them on the Underground Railroad immediately, and they start working their way up from one Quaker house to another, where they get across New York State, and they get to Buxton, Canada. The last we hear of them, as a matter of record, was a year later. They're in Buxton. John Jay is sending them $100, just, because he's that kind of a guy. And we know they're in Buxton. That's the last we hear of them in the public record. But there's a side to this, which I'll get to a little bit later.
Is that the only person they had to pay? Is that the only money that was given out at that time
to goodness. Yeah.
What else happened?
What else happened? The merchants in New York felt so sorry, not for the slaves, but for the Lemon family, because the merchants wanted to maintain business ties with Southern exports, Southern cotton, Southern corn, Southern banks, Southern loans, Southern manufacturing. There was a brisk commerce, and they didn't want to upset the apple cart and breach the union and breach the good relations. So the merchants raised market value of the slaves, and they gave it to the Lemons so that the Lemons could be made whole. So the Lemons are made whole.
How much?
$5,500, a vast amount of money. In 1852, that's an enormous amount of money. It was the value of 8 human beings. So they get their money, and as lawyers, we know what happens now. We're going to use the word standing. What happens? The subjects of the habeas corpus are gone, and the Lemons have settled their way out. They got paid. They're paid so that they are no longer aggrieved.
So they agreed not to turn around and sue again. That was done. They're
They're
settled.
paid, they're aggrieved, they signed a bond, they're done for. What's left of the Lemon case? As lawyers, I ask you, you might correctly say nothing. However, at this point, in comes Virginia, and they go before, what was the appellate division, and they say, you're listening to this, right? I don't know how you would rule, but they come and they say, we're Virginia, the Lemons are gone, but we want standing because we care. We want to appeal this case because we don't feel free to come to New York anymore with our slaves. So we are aggrieved. And the judges are listening, and Erastus Culver is arguing against them. He says, you're aggrieved? Why don't you folks go back to Virginia and stop imprisoning people for teaching black kids how to read? That was his affidavit. You gotta love this guy. So that was his answer, like, get lost. But the judges said, okay, we'll hear you. They gave Virginia standing to appeal. Virginia then comes in with
You have to write a book about Erastus Culver next time.
Well,
That's
yeah,
the
let's
next
do
one.
it. Okay, yeah.
Sounds like an interesting
Yeah, great guy.
Anyway, sorry, I interrupted. So Virginia comes in,
Virginia
and
comes
they're
in.
coming to the,
They hire the most prominent lawyer in New York and maybe America, named Charles O'Connor. I don't know whether any of you know that name, but he was all the big cases, the big money cases with the banks and the politicians. Charles O'Connor was the lawyer of the day. The other side still had John Jay, but he was stepping out of it, and in comes Culver's successor. Culver went on the bench. He's now a judge in Brooklyn. And who's the young lawyer in Culver's office whose name is now on the record as the attorney of record? A young kid who just graduated law school, didn't have much to do with the case, but his name is the attorney of record. Names happen to be Chester Arthur, who later becomes president of the United States. So Chester Arthur, in his obituaries, Chester Arthur said, yeah, I was part of that Lemon case. He loved being part of the Lemon case, even though he was candid enough to say he really had no part of it. He was the attorney of record. So it's just an interesting, fascinating little sidelight. So the slavery side hires Charles O'Connor, and the New York side, by this time, New York is now in the case, so it's Virginia against New York. New York steps in because the subjects are in Canada, so New York is now the party. So it's now Virginia and New York. It's now a political case. And John Jay comes in and asks for dismissal. He says, this is politics now. This is no longer a lawsuit. This is politics. We want this case dismissed. Ask the appellate division says, no, we want to hear it. Maybe because the appellate division said, we've got a lower court ruling, we want to hear it. For whatever reason, they just felt they wanted to hear the case. So they hear the case, and we also have a record of that case, and we have the arguments, we have the brief to the appellate division, and
although we weren't called the appellate division, the general term.
Supreme Court general term, thank you. Supreme Court general term. It morphs into the aptive in 1894 when the first department is created, et cetera. So Supreme Court general term, they review the decisions of Superior Court. So you look at the briefs to the general term, and you look at Charles O'Connor's briefs, and you would not believe what he's writing. He's not centering on the Commerce Clause or the full faith and credit or even comity. His argument is that the blacks should be happy that we took them out of Africa and we civilized them. And there's no way they'll ever get along without white guardianship. So therefore, that's the ruling that should come out, to leave them in their place and give them a better life, because if they're freed, they're going to do nothing but get into trouble because they're barbarians. That's the brief that he writes, mind you, to the general term.
Now, what year was that?
1857.
And Dred Scott?
Dred Scott was on the books. Dred Scott had just been decided 7 months before O'Connor is spewing out this garbage.
So that, what O'Connor says, sounds very much like what one of the lower court opinions was before it got, in Dred Scott, before it got to the Court of Appeals.
I'm not sure if
in Dred Scott, before Dred Scott got to the Court of Appeals, it started off.
Dred Scott was in.
I'm sorry, before Dred Scott got to the Supreme Court.
Right.
In
it was
the
in
state,
Missouri.
Exactly.
Right.
And what he is espousing.
Yeah.
There at general term sounds very much like what one of the opinions was in the state
argument,
court.
For their own good type of argument.
Yeah, it was very derogatory, that state court. That opinion was awful.
So let's see, where are we? We're now in the general term, Supreme Court general term. And this is a caution to all lawyers when we go to these law clinics. We say, know your audience. And he's talking to the judges on and they're listening.
He's talking like he probably talked at the Supreme Court. He's speaking to the general term.
really. So they were polite enough, to just be quiet and saying, all right, spew yourself out, but we're sitting there with the pen. And they write what is one of the most beautiful appellate division writings. They were not swinging for the fences. They did what appellate divisions do so well. Once in a while, the appellate division swings for the fences. You do that a few times a year, and you hit it out of the park. And the rest of the times, they're just good mems. So they write a mem, and they write just a beautiful mem, and it's something like, look, we have a statute. The statute says that New York formerly used to allow slaves to come into New York for 9 months, and if they stayed longer than 9 months, they're practicing slavery, so we're not going to allow it. And we used to allow slaves in New York for 9 months, but we abolished that in 1841. So now it's 11 years later. The statute that used to have this 9-month provision was stricken. And the legislature just said the 9 months sojourning for slaves in the state of New York is stricken. And the appellate division says, we have a statute. They struck the 9 months provision. 9 months minus 9 months is 0. So that means when you set foot in New York, you don't have 9 months anymore, you have 0, right? You get the arithmetic on this, right? So they just said, we have a statute. We're not gonna, that's all. Thank you very much, 1 paragraph. And it was just one of the richest decisions I'd ever seen. That's how good it was. So that's now 1857. Did Charles O'Connor pound the table and says, you cannot do this under Dred Scott? No. For some mystery, one of the premier lawyers in America did not rely on Dred Scott, just mentions it in passing, maybe in one sentence, and the general term just ignored it. It wasn't pushed on them, and they didn't feel necessary to deal with it because the lawyers barely even mentioned it.
So did they seek cert?
Then, next thing you know, Virginia seeks appeals to the New York Court of Appeals. It's now...
Oh, right, you said we were in the appellate term, right.
So we're now going before the New York Court of Appeals. Where should I get back on this? Let's see.
I'm jumping ahead.
Yeah, here we are. Oh, this is perfect.
Yeah.
So we're now, you folks, if you don't mind, you folks heard the case in 1857. You affirm 4-1. A silent dissent by one judge. I dissent, no reasons given, just I dissent, we don't know why. And 4 judges write this beautiful mem affirming. It's now 1860, and the case is now being argued before the New York Court of Appeals, right around the end of 1859, the beginning of 1860. The room would have looked very much like that. I find an old postcard, and that's pretty much the way it would have looked. And they go before the New York Court of Appeals, which then, for odd historical reasons, which I can explain to you maybe if anybody's interested, had 8 judges, not 7. It's a quirky number because 8 is not a happy number for an appeals court for obvious reasons. They listen to the argument. Now, Charles O'Connor is on one side, and on the other side, William Evarts. Oh my, oh my. If Charles O'Connor is the premium lawyer in New York, William Evarts is right next to him as one of the New York's greatest lawyers ever. Later became Attorney General of the United States and became a United States Senator. And by the way, just happened to be Archie Cox's grandfather. Just one of those family things that just happened down the line. So William Evarts was one great guy, and he wrote a magnificent brief to the New York Court of Appeals, right on target. And Charles O'Connor is still writing this stuff about, we've got to keep them in their place. And the judges are sitting there and they're just, listening. And 5 of them are saying, all right, they're not addressing him. They're not going to I mean, they're not going to engage Charles O'Connor. They're not going to engage him. Why would they? They're sitting there. They've got the pen, right? So they write up the decision to affirm 5-3. They affirm by rejecting the due process, by rejecting the full faith and credit. How do they reject full faith and credit? They say, we understand full faith and credit, but under full faith and credit jurisprudence, we will not accord full faith and credit to a judgment that we think is obnoxious to us and to our thinking. So that's the law today. We will not enforce we will not give full faith and credit to a judgment of another state. We will not, and you will not, if that is obnoxious to your own jurisprudence. So they say that so much for full faith and credit. Interstate commerce, we're not buying that because when you're in New York, we control what happens within our borders, so we're not buying that. What else? Comity. Well, comity, that got them a little bit uncomfortable because, comity means showing respect for the other state, not full faith and credit, but be nice to the other state. And 3 judges on the court said, what we're doing here is not right. All they're doing is passing through New York. They're not practicing slavery. So this seems a little harsh to us, to these 3 judges. And they said, well, comity plus what they're doing is minimal by way of slavery, so we would reverse general term. But the case came down 5-3 to affirm. It's now April of 1860.
And so now my last question, because I said I was forgetting where we were. Did they seek cert?
Did they
seek
look
cert
for
to
right.
the Supreme Court?
This is a question that I think probably maybe someone someday will answer it, but the answer is not around for the foreseeable future. It's now 1860. They get the New York decree. They have 30 days, 60 days, 90 days to look for cert to the U.S. Supreme Court. There's no record of, the U.S. Supreme Court never gets the case.
Which seems hard to believe because they had a slam dunk
They had a slam dunk
decision.
Supreme Court.
I mean, good thing they didn't, but they had a slam dunk decision.
Did Virginia file a notice of appeal? Did they even file? Had they filed, the court may not have heard it because the Civil War came, right after that. Did they file? Well, I'm reading a couple of history books that seem to say that they filed. So I don't know the answer. So I call up the Library of Congress. And if you're making enough phone calls with the Library of Congress, they're very good people. Eventually you get to the right person. And I finally get to somebody's desk who's in charge of all the records of the United States Supreme Court. The guy's name is Ennis. I say, Mr. Ennis, I'm writing a book, and I would like you to tell me whether anybody ever filed a notice of appeal. Not that the court heard the case. We know the court never heard the case. Did Virginia ever appeal? He said, let me get back to you. Gets back in a few hours or a day. He says, no notice of appeal ever. I said, are you sure? He says, I'm positive. I said, Mr. Ennis, I don't mean to be harsh or anything, but I'm putting you in a footnote. I'm going to say that Mr. Ennis of the Library of Congress told me that there is no notice of appeal, and I have to do that as a writer. I can't say it on my own. He said, may I do that? He says, yeah, nobody ever filed. I said, okay, there it is. So it's in footnote number 200, whatever it is. So that was it. And why did they never file? Can we guess?
They made a mistake. Somebody didn't communicate with somebody. The war broke out.
We'll never know. Maybe there's a few theories. Governor Letcher, who would have been the one to see to it that disliked intensely the predecessor, who was an ardent slavery person, and maybe Letcher was a little bit soft on it and said, look, we're about to go to war, I don't want to bother with this. That's theory A. Theory B, which is probably what happened. Somebody in the office said, oh, I thought you were going to file. Oh, wait a minute, didn't you say you were going to? That's the way the world works, right? So we don't know, we'll never know.
A mistake. So, for yes, law, law.
Yeah, law of failure, very good.
So, this didn't end there for you.
Right.
You pursued this further.
Yeah.
Why don't you tell us how, with the family of, the Lemon slave case?
Okay, so this is a fascinating, this is really kind of a heartwarming ending to it. The last we hear of the Lemons in the public record is 1852, when John Jay sends them maybe $100, and that's the last we hear. So I'm writing it. It's unthinkable that I'll ever find any remnants of their offspring, and it never crossed my mind that I would. But I called Buxton, and in Buxton, there's a historian there who has all the records of all the people that were on the Underground Railroad, thousands and thousands and thousands of records.
So that's the last stop. Buxton is the last stop on the
stop, and he's
Underground Railroad.
He's the historian. So I got to know him a little bit. We became internet pals over a few months, and I call him up. I say, you know the Lemon case? He says, yeah, of course I know the Lemon case. I said,
he's better than we are.
Any chance you know what became of them? He says, oh, no, they have names like Thompson and Jackson and Johnson. So that's the end of that. And I'm about to send the book off to the publisher. I contact him again. I say, I'm about to send the book off. Can you give me a sliver of a hint, of an iota, of a clue? And he gets back to me in a day or so. He says, I'm guessing that of the 8 of them, the 5-year-old twin left Canada and went to Lansing, Michigan after the Civil War. His name was Lewis Wright. We know there are 2 5-year-old twins among the 8. So now I have a name, Lewis Wright, and I have a city, Lansing, Michigan, and that only leaves like a few hundred names. And then with after a while, you just start doing this. You can start matching up birthdays, where he was born, and where he was married. I have him married in Ypsilanti, Michigan, in some year, and the next thing you know, my living room looks like a scene with arrows and pictures and all over the place. And I say to my wife,
homicide
Julie,
scene.
Huh?
A homicide scene with the tape
scene.
all over the floor.
I said, Julie, I think I got him. I think I have Lewis Wright getting married in Ypsilanti, Michigan. And once you have a marriage in Ypsilanti, Michigan, you can find your way with the internet with the Michigan marriage records, and then you can get the obituary records, you can get the birth records, through the newspapers and so forth. So I then track this 5-year-old, who's now like 20, and I track him 7 generations forward. Luckily, Lansing, Michigan is a city with a sizable black population. So they have, in the New York Times, it would only be the white society that gets married. Only white people that are rich could get married in the New York Times, not the likes of me or most of us here. But in Lansing, it was a significant black population, so people got married, it would be in the newspapers, not only the white society page, like in the New York paper, like the rich folks of the 400 that were in the New York Times. So I was able to find them through marriage records. 7 generations later, there's a name, and I have a name, it's still in Lansing. And I call up the guy with a long introduction. Please don't hang up. I'm not trying to do some con, even though I know every con begins by saying,
Don't
I'm
hang
not
up.
doing a con.
I'm not doing a con.
And after a few minutes, he believes me, and when I say, I think your grandmother was, something like Flossie Moore, is that right? He says, yeah. He says, well, in that case, you may not know it, but you're part of a very, very important family. And we became friends. And we then had a Zoom with all of them who descended from this 5-year-old twin. So we got to know them, and we had a wonderful time on the Zoom. They had a different story. They didn't know they were from this litigation at all. They had other stories about how they came to be where they are. And so we got some pictures. Oh, there's Chester Arthur on the docket of the New York Court of Appeals. Oh, wait a minute. There's Charles O'Connor. Look at him sitting there, smug as can be. And Everts, who you gotta love, William Everts. Doesn't he have character in his face? Look at Everts' face. I'll tell you a little more about Everts in a moment. In Lincoln's speech, in a footnote that we found, he said, watch the Lemon case. This could be the other shoe dropping after Dred Scott. I get this picture from the family, and our guy, the 5-year-old, is seated. That's his twin brother. We never found them. No one ever knows anything about the twin brother. The family lost touch with him. I looked hours and hours trying to find the twin brother. I couldn't find him. The family couldn't find him. But our guy, Lewis Wright, is seated. Lewis Wright turns out to be a fascinating guy, a very good baseball player, fortunately. So he's among the first African-American baseball players in Lansing. Oh, I guess
in the Negro Leagues?
Oh, I guess that's it. So I was able to find him through the newspapers because he's a baseball star, and I see a lot of Lewis Wright in the newspapers.
So I want to leave time for questions, but I do want to ask you if you think the Lemon slave case had any impact on the Civil War, or whether it was something thought of, by the South.
Wow, isn't that a fascinating point? If you were to go to the internet and look up the secession, right after the Lemon case, the South started to secede. The first state to secede was, I don't expect you know this, I didn't know this. Historians may know this, and you could look it up, of course, it's a matter of fact. South Carolina was the first state to secede. They seceded 9 months after the Lemon case. And if you go online and look up South Carolina, in their secession statement, they give a whole bunch of reasons, and then they say, and not only that, but those judges in New York, and they're talking about the Lemon case, and they're blaming us for their secession. Isn't that wonderful?
Well, if Lincoln is talking about it in a speech,
Yeah.
then it was known far and wide,
Yeah.
and one might expect that they might be concerned.
Oh, one other little thing, as lawyers, Dred Scott is out there, and the judges of the New York Court of Appeals know that Dred Scott is out there. How do they deal with a case of the United States Supreme Court that says the Fifth Amendment, no less, is before the 14th Amendment, which was a few years later. Fifth Amendment says that no person may be denied life, liberty, or property. That's what Roger Taney hung his hat on in the Dred Scott case. And he says owners may not be deprived of property. And that's why they decided Dred Scott as it was, because Dred Scott's owner would be denied property, namely the slave as an entity and as a chattel. That's what the Dred Scott case stands for. And they used, mind you, of all things, the Fifth Amendment that speaks of life, liberty, or property. Life and liberty, forget that. Forget the life and liberty part. It's the property part that Taney hung his hat on. So the judges of the New York Court of Appeals know this, and they know the Dred Scott case. How do they get around it? This is very, very deft. I think there are about 5 opinions in the Dred Scott case. So books have been written trying to figure out the Dred Scott case because it's so complicated. But we do know that there's a majority, when you look at all the plurality opinions, there's a majority that says what it says, but that basically, at the core, the Dred Scott case was decided on procedural grounds. Dred Scott, a citizen of Missouri, is suing his owner, Sanford, for liberty. In order to bring a suit in a federal court, you need diversity of citizenship. So Dred Scott has to establish himself as a citizen of one state and Sanford the citizen of another state. In the opening paragraphs, the court says, Dred Scott cannot be a citizen of anything because he's not a person. So he lacks capacity to sue. The rest of the 50 pages, we say, is dictum.
That pretty much sums it up.
That's what William Wright said. The majority, there were two majority decisions in the Court of Appeals. The one majority decision didn't address Dred Scott at all, but in William Wright's, the second majority decision says, okay, all right, we have to talk about Dred Scott. Here's Dred Scott. It was decided on jurisdictional grounds, and we consider all that other stuff as obiter was the word he used. It is obiter. We don't use the word obiter much anymore.
I don't think we've used that in the decision, at least not in my term.
Obiter? Do we talk about obiter?
No. Well, I want to thank you so much. This was very, very interesting, and I know there's so much more to go because you really do, yeah. You really do explore the family, and with travels to Buxton and meeting, the descendants. But perhaps we can discover more with questions. Anyone have any questions?
Or comments?
Or comments. So you did venture off to Buxton with your wife?
Yeah, I came to learn that, when you become pals with these folks in Buxton, that every year, I didn't know this, I came to learn it, the descendants of the runaways have met every year on Labor Day weekend in Buxton, Canada, and they have their celebration.
So the descendants of all the slaves who used the Underground Railroad.
Hundreds, thousands of them. And every year on Labor Day, they have a few hundred people that came to Buxton. So they invited us. We were like, we were like celebrities up there. We got to pal around with everybody, and they put on a play. They dramatized. They knew the book, of course, and they dramatized the play. And they put on a performance of the play, and we're sitting there with the actors. So they invite us to a rehearsal of the play. This is what they say. So the guy is playing. One of the guys is playing Erastus Culver. And I said, "What do you think?" I said, "I give him a little more zip. He was a feisty guy. A little more zip." No, okay.
Well, thank you so much. Really appreciate it. This was wonderful. Thank you.
Very good.
We're waiting for the next book where you're going to unearth some other fascinating piece of history that needs to be put on a platform. Yes?
And any plans to develop a screenplay for this to be like a feature film? So, because the characters are just so, larger than life. And it's just a very compelling story that's, any plans for that?
Well, I would love that. If any of you know Steven Spielberg, that'd be good. But there's a dramatic moment in there that I'll just touch on for a sec. When they were in the courtroom before Judge Payne, not knowing how the case was going to be decided, they're sitting, imagine it was, a little bit like this, and the Lemons are on one side, and the two moms are on the other side with babies. And the Lemon woman, Juliet Lemon, during a recess, goes over to Emmeline, the mom, and says to Emmeline, "Why are you doing this to us? You're stripping us of our only asset. Don't we have a good life together? Don't we eat off the same plates?" That may have been figurative, I don't know. And aren't we all going to have a good life together in Texas? Aren't we one big happy family? She's telling that to Emmeline. And Emmeline says, according to some newspaper reporters who were in the room listening to this, Emmeline says, "We're not one big happy family. You sold my husband." So they are. That's a moment for Steven Spielberg.
What about Mustafa Khan? What was his role in, after, of course, the book and everything else? Was it a blog where there, Mustafa Khan?
Well, yeah, Mustafa did a 10-minute dramatization.
He's a
with real
director
actors.
or
Yeah, filmmaker.
filmmaker.
I think it's online. Oh, no, we're waiting
I
for some
think
kind of
it's online.
copyright, some music copyright. Mustafa Khan is a good filmmaker, and he got real actors to play the parts. And we heard the actors, and I was particularly interested in Emmeline. You know, I wanted, you know, he's asked me what I thought. I had no say in it, but he portrayed he brought some of the actors. He says, let's pick out who would be a good Emmeline, and he asked what we thought. So we got to hear some of the actors. And I thought Emmeline should be someone who was able to combine fear and the notion of processing freedom with a monumental backbone. You know, how do you do that as an actor? Well, you know, actors, yes.
I guess, because there was real fear. I mean, if this didn't work out and they had no idea whether they would be successful, they would either have to chance it, and if they even got to walk out of there, I imagine they would have been in custody if it was over, right there in the courtroom. They wouldn't have had a chance to even try to get to the Underground Railroad.
Right.
And if they were taken back, who knows what would have happened. You have to teach someone a lesson if they
That's right.
they stand up to you like that and
That's
ignore it. So that would have been a bad scene.
She didn't know. They had no idea how Judge Payne would rule. No one could possibly have known. And I'm guessing that when he got the case, he himself didn't know. He was a very good listener, and I know there are often when you come out on the bench, you may have a leaning one way or the other, but a lot of times you just say, let's hear what you have to say. You know, mine is totally open. So I learned a little bit about Elijah Payne. Do we have time?
Well, we don't, yeah, I mean, we can continue for a little bit longer.
All right, I learned a little bit about Elijah Payne because he's nowhere online. His father is online, but the Payne family is well known, and I was able to, one of the people in the Payne family said, yes, they sent young Elijah off to Harvard at age 15. In those days, the people of that, you know, in that station, they'd send him young, he was from Vermont, so they would send him to Harvard. That's like where they would go, because it's closest to Vermont. So, you know, of the fancy schools. So I then contacted Widener Library at Vermont, at Harvard, and they said, I don't know whether, I learned that you could do this. It came as a great surprise to me. I said, can you go back to the class of 1814 and tell me if you recognize Elijah Payne? You know, then I gave his dates. They said, yes, we'll get back to you in 48 hours. Sure enough, after X hours, they come back and they say, yeah, we have Elijah Payne. What would you like to know about him? I'd say, well, what do you have? They said, we have his address that he gave the class when everybody in their 25th reunion gave their bio, what they're doing in the 25th reunion. Elijah Payne gave his little essay of what he was doing for the last 25 years, so I got that. It is hilariously funny. It is side-splitting. He had a great sense of humor. And I said, there's one more thing I forgot to ask you. Can you tell me what courses he studied? And I asked that question because in his decision, he's citing Grotius and Pufendorf and some of the political scientists about political science and liberty and ownership under international law. And he's citing Grotius and Pufendorf, the great political philosophers. And I get his curriculum, and sure enough, the juniors in his year were studying Grotius and Pufendorf. I saw those names, or at least Grotius, and one other political philosopher, and I thought, this is unbelievable.
Well, we could go on for hours. This is so fascinating. You've found so many interesting tidbits, but unfortunately, we have to end. So you can come back anytime. Thank you. Thank you, everybody.